Well, the U.S. Supreme Court term ended with a bang. The High Court issued controversial decisions in its final days that reconciled open issues involving landmark decisions from 2 years ago. We'll start this month's program by looking at how much tax planning certainty or uncertainty businesses now have and what they should be doing based on the Supreme Court's decision to 1. Affirm the validity of Obamacare in general and the Affordable Care Act in particular, and 2. Uphold the equal protection right to same-sex marriage. According to the news media, the Supreme Court handed the Obama administration a key victory by upholding the tax credits that allow many low-income Americans to purchase health care insurance in those states where the federal government is running the insurance marketplace. These tax credits, available to Americans with household incomes between 100% and 400% of the federal poverty line, operate as a form of premium assistance that subsidizes the purchase of health insurance. The petitioners in King v. Burwell challenged a ruling from the Internal Revenue Service. They claimed that a phrase in the Affordable Care Act indicating that the subsidies are only available to consumers buying insurance in a state-run exchange prohibited the federal government from providing tax credits where states have not established their own exchanges. But the Supreme Court sided with the Obama administration in its 6-3 decision, emphasizing that the statutory language allowing tax credits for health insurance purchased on, quote, an exchange established by the state, end quote, must be interpreted in context and within the larger statutory scheme. Because the tax credits under the ACA are central to the reforms created by the law, Chief Justice Roberts explained Congress would not have delegated such an important question to any agency, and especially not to the IRS, which lacks expertise in crafting health insurance policy. For most companies involved in the healthcare system or in providing health insurance, the result of this decision means business as usual. But the decisive victory of the law means that the Affordable Care Act is here to stay and will have a permanent effect on how patients access care. While the Supreme Court upheld the so-called individual mandate 2 years ago, the latest decision, King v. Burwell, effectively upholds employer penalties, or what is known as shared responsibility payments. As a result, employers understand that they can be penalized for their failure to offer affordable, minimum value health coverage to all of their full-time employees. And those shared responsibility payments are already in effect for applicable large employers in 2015, those with 100 or more full-time or full-time equivalent employees, and in 2016 for those with 50 or more full-time or full-time equivalent employees.
Returning to our program is attorney Jeffrey Kolodny with the Manhattan office of Cozen O'Connor, where he is a member of the Private Client Services Group. Thanks for joining us again, Jeff.
Thanks for having me, Mike.
Our first case today, Jeff, is deja vu all over again. 2 years ago, we discussed NFIB versus Sebelius, and now the Supreme Court has handed down its decision in King versus Burwell. What was at stake here?
This case could have caused significant harm to the Affordable Care Act. The case could have eliminated subsidies in the 34 states that didn't have a state insurance exchange but were relying on the federal exchange. This could have made health care costs unaffordable in those 34 states. If healthy people left the exchange, it could raise the cost on the other people who stayed in the exchange.
Of course, for our viewers, this case may have another meaning. 2 years ago, the High Court upheld the individual mandate, but in King versus Burwell, they are essentially upholding the employer mandate as well, aren't they?
That's right. Even though the case didn't specifically address the issue of the employer mandate, based on the terms of the Affordable Care Act, the result of the case is that employers are going to have to continue to pay the insurance, and the employer mandate continues to exist.
Isn't this decision of particular consequence to the so-called applicable large employers who have shared responsibility payments beginning in 2015?
That's right, Mike. If your company has 50 or more full-time equivalent employees, you're required to report, provide the insurance, and if you don't, then you're going to be subject to penalties.
Okay, so from your perspective, what should companies be doing now? What are you advising your clients?
One of the things that employers should be doing is tracking the hours of employees to know whether or not you've got more than 50 full-time equivalent employees. Another thing that they want to do is evaluate whether you've got an employee or an independent contractor, whether they fit under the regime or not. Finally, Mike, you're also responsible for summary plan descriptions and employee communications. You want to update them to make sure that they're proper.
We've got a number of other topics to discuss today, Jeff, so let me ask you, is this new case the final word from the judiciary on Obamacare?
I don't think so, Mike. Just like other cases, just because there's a Supreme Court decision doesn't mean that that's the final word on the matter. There's a lot of opposition to the Affordable Care Act, and I think that you're going to see a lot of movement in the states and maybe in the Congress to try to curtail it, chop away at certain aspects of it, and you might see other lawsuits dealing with other aspects of the Affordable Care Act as well.
Thanks, Jeff. We'll return to your commentary in a minute.
In a second end-of-term blockbuster, the U.S. Supreme Court handed down its monumental decision in Obergefell versus Hodges, legalizing same-sex marriage across the nation. Flowing from this recognition, the High Court held that states must recognize same-sex marriages that were lawfully licensed and performed in other states. But as earth-shaking as the Obergefell decision is societally, the implications for employment policies and benefit plans are modest in comparison. Viewers will recall that 2 years ago, after the Windsor decision, both the IRS and the Department of Labor issued guidance establishing that the definition of spouse for any federal tax or benefit purposes includes a same-sex partner from a marriage recognized in any state, even if the employer and employee reside in a state that did not at the time recognize same-sex marriage. So if anything, entirely removing the ban on same-sex marriages may simplify tax and ERISA administration for employers. Of course, the decision doesn't impact all employers equally either. For those employers who had provided benefits to same-sex couples previous to Obergefell, the decision will make barely any waves. In fact, the ruling will actually just simplify matters for the most part for these employers. Most notably, employers operating in states that previously banned same-sex marriage will no longer need to calculate imputed income for state tax purposes in regards to employer-provided health coverage for same-sex spouse. Generally, the cost of employer-provided accident or health plan coverage for employees and their respective spouses and dependents are excluded from employee income for income tax purposes. But this exclusion doesn't apply for someone included on an employee's plan who is not a spouse or dependent. Instead, the cost for covering that individual, such as an employee's same-sex spouse in a state that did not recognize those marriages, was to be counted as employee income for tax purposes, requiring the employer to withhold income and payroll taxes on this income. Obergefell eliminates this requirement, which frees employers from having to make this imputed income calculation for employees living in states with pre-Obergefell marriage bans and allows for consistent tax withholding in all states in which the employer operates. For those employers operating in states with pre-Obergefell marriage bans and that excluded employee same-sex spouses from employer benefits, things are likely going to change under the ruling. Specifically, the changes will be seen for those employers with fully insured plans in which the employer purchases health insurance for employees from an insurance company. Because those plans are regulated by state insurance laws, which will now interpret spouse in a gender-neutral terms under Obergefell, employers can no longer exclude same-sex spouses from those plans.
Well, Jeff, by now, most of us have already heard that the U.S. Supreme Court affirmed a constitutional right to same-sex marriage in all 50 states. What exactly does that mean?
So Obergefell is a very important case, Mike. It grants a fundamental right under the Constitution for same-sex couples to marry. It requires states to issue marriage licenses to same-sex couples, and it also requires states to recognize valid out-of-state marriages. The decision also nullifies bans in certain states on same-sex marriage.
Now, I'm not being a wise guy, Jeff, but tell me, if there's a fundamental right to same-sex marriage in every state, will there also be a fundamental right to same-sex divorce?
That's a good question, Mike. Before Obergefell, we had situations where certain states would allow same-sex couples to marry, and if they moved to a state that didn't recognize same-sex marriage, and the marriage went sour and they wanted to get divorced, there was no way for them to get divorced in those states. Presumably under Obergefell, now that all states have to recognize out-of-state marriages, there will be no ban on the ability to divorce. No impediment on the ability to divorce.
Well, 2 years ago, you appeared on this program and you analyzed the High Court's Windsor decision for us. Now remind me, why was it even necessary for the court to take and to decide the Obergefell case?
That's a very good question, Mike. The Windsor case, which was decided 2 years ago, didn't have anything to do with the fundamental right to same-sex marriage. In Windsor, the court was evaluating whether certain provisions of Section 3 of DOMA, the Defense of Marriage Act, were constitutional. So the good news about Windsor is that it struck down those provisions of DOMA which prohibited same-sex married couples from getting federal benefits. What it didn't do was address the fundamental right to marriage. And so you still had situations where states could prohibit or not recognize same-sex marriage. That's what Obergefell decided.
In addition, I suppose it means that something as basic as the right to visit a spouse in a hospital is now certain for same-sex married couples.
That's right, not only with regard to hospital visits, Mike, but really any benefit or right that a spouse had should be afforded to same-sex married couples as well, whether in the state of the marriage or in a different state, if that state didn't previously recognize same-sex marriage.
Now, I want to ask you about gifting and estate planning in a minute, Jeff, but what about that same-sex couple who were taxed at the state level on spousal health benefits, or who were able to file a joint return for federal income taxes, but were still required to file 2 individual returns for state purposes? Can they now go back and file refunds for past open years?
That's a good question, Mike. After the Windsor case, the IRS came out with guidance that provided that a same-sex couple that had been previously married could go back and amend their federal income tax returns for the period, for any returns that are open under the statute of limitations. Now, we don't know what states are going to do after Obergefell, and it's very soon after the case right now. But presumably, it would seem that states should be issuing guidance to provide for the ability to amend tax returns, especially if they take the federal lead after what happened with Windsor. You asked me, Mike, whether married couples should go back and amend their state returns. And I think that is going to depend on their particular situation. It may make sense if they don't suffer from the marriage penalty not to amend, but if they do, it may very well make sense for them to go back and amend their returns and get some refund. Some cases might be a slam dunk, Mike. It depends. 2 years ago, you asked me about a married couple who had previously sold their home for a profit, and they wanted to take advantage of the Section 121 sale exclusion on capital gain. In that case, obviously, it would make a lot of sense. If there are similar opportunities on the state level, it would make sense for them to go back and amend their returns.
You've told me in the past that a big advantage of married status is that you can make unlimited gifts to your spouse without worrying about federal gift taxes. But let's say that a couple lives in Connecticut, one of the states where there's still a state gift tax. They buy a house together, but they put in different amounts towards the purchase price. Was there before, and is there still, a state gift tax consequence for them?
We've always been concerned, Mike, for situations of unintended gifts with regard to transfers of wealth between spouses. So before Windsor, in addition to same-sex couples losing the marital deduction, you'd have that in an unmarried couple living together or a married couple with a non-citizen spouse. So after Windsor, it's clear that a gift from one spouse to a same-sex spouse is eligible for the marital deduction as long as the recipient spouse is a citizen of the United States. So if there were states with a gift tax that didn't recognize same-sex marriage, it would seem to me, depending on the legislation, that it should follow that you should be eligible for a marital deduction in that situation as well. We'll have to wait and see the guidance that the states issue. So the bottom line, Mike, is that the unlimited marital deduction for gifts or transfers at death should apply as long as the recipient spouse is a citizen of the United States. regardless of which state in which they reside.
Now, Jeff, remind me, why is the so-called spousal exclusion such a basic but also significant estate planning principle in this country today?
So this year, each individual can transfer $5.43 million free of gift or estate tax, whether the transfer is during life or at death. For a married couple, you can double that amount, and with some effective planning, whether it's transfer of assets and using credit shelter planning or using portability, even if one spouse doesn't have the full amount of the exemption in assets, the couple together can take advantage of the full double exemption amount, close to $11 million this year. So effectively, this helps to reduce the estate tax burden on many married couples.
Well, that makes sense. And 2 years ago, you told me that the spousal exclusion was extended to same-sex couples at the federal level. Now, presumably, it's also extended to the state level as well. So remind me, how many jurisdictions still have an estate, an inheritance, or a death tax? And is it something for which people still need to plan?
You know, one thing that you need to do in taking into account your state level estate tax planning is to make sure you know which state you might be treated as a resident of. If you live in multiple states, you want to nail down and plan perhaps on guaranteeing which state will treat you as a resident for state tax purposes. 15 states and the District of Columbia have state level estate taxes, and 6 states have inheritance taxes. Maryland and New Jersey have both an estate tax and an inheritance tax. An estate tax is a tax based on the value of the property when someone dies, whereas an inheritance tax is based, the tax rate is based on the relationship of the recipient to the person who's died. In a lot of states, the state estate tax rate goes up to 16%. So this really is something that people should be paying attention to and focusing on. The good news is there's some really good planning opportunities at the state level. The bad news is you have to look and be very careful about the rules in the specific state. For example, in my state, New York, while there's federal portability, there's no portability on the state level, so it really makes sense to do credit shelter planning.
Okay, I understand what you're saying about planning for state death taxes, but Jeff, let me ask you, we've also heard reports from our viewers that estate tax returns are receiving increased attention from state taxing authorities. Are you seeing that too?
I agree with your viewers, Mike. We are seeing an uptick in the level of state-level audits. It used to be, in a lot of states, including New York, that the New York State Taxation Department would rely on the findings of a federal audit. With the increased exemption levels and for various reasons, budgetary constraints, the states are realizing that there's money to be found, and so they are paying a lot more attention, maybe because the IRS is not focusing so much on certain estates, but there are opportunities, and we are seeing audits on the state level.
Now, Jeff, if you don't mind, I'm going to ask you the same final question about Obergefell that I asked you a few minutes ago regarding the Affordable Care Act. Is this truly the final word from the judiciary on this subject?
You know, Mike, Obergefell is a very far-reaching case, and the whole concept of same-sex marriage is evolving very, very quickly. After the decision came down, there were presidential candidates and a lot of other people who were criticizing the case. I think that there's going to be legislation and attempts to chip away at the concept and the provisions of what states provide as far as same-sex marriage, and I think this is going to be a contentious issue for some time to come. You may find that states are enacting legislation to try to erode the principles of Obergefell, and who knows, county clerks may refuse to issue marriage licenses. Certain people may refuse to conduct marriage ceremonies. I think that there's going to be some more that we see in this regard.
Well, since you mentioned the 2016 presidential candidates, Jeff, I was reminded that for the last presidential election, you analyzed the tax returns of the final 2 nominees. Are you ready, willing, and able to perform the same function for us next year?
I'd be glad to, Mike.
Building assets for retirement may seem like a challenge enough, but once you've got that figured out, you still have to designate beneficiaries who will take control of the assets after you're gone. After all, retirement plans, annuities, and life insurance policies all let you decide what should become of your assets in the event of your demise through the designation of beneficiaries. Beneficiaries can include those who leap to mind: spouses, children, and other relatives. or they can include friends, trusts, charities, and institutions. But in either case, beneficiary designations generally kick in immediately after death and override a will. That means you need to ensure that your beneficiary designations reflect your most recent wishes because your will cannot override them. For example, imagine the following scenario. Father is a very successful insurance broker. Among his assets, a deferred compensation arrangement, a 401k account, other pension benefits, as well as life insurance and an IRA. He marries wife Diane and names her as sole beneficiary of some of those assets and as co-beneficiary with a son from a previous marriage of others. Unfortunately, father and second wife Diane get divorced. Pursuant to the divorce decree, father agrees to keep $1 million of insurance on his life for ex-wife Diane's benefit. Father dies in 2009, never having changed any of his beneficiary designations. In two recent court actions, the son, as well as the company, was surprised when courts decided, 1, ex-wife Diane received father's deferred compensation and pension benefits since father never changed his beneficiary designations before his death. And 2, ex-wife Diane is not liable for the $350,000 of tax attributable to the non-life insurance assets she received.
As Becky just described it, our next case involves one aspect of tax and property law. Who is a beneficiary? Now, before we get to the facts of the case, Jeff, remind me, doesn't ERISA prohibit workers from waiving certain employee benefit rights without their spouse's approval?
That's right, Mike. In an ERISA plan, if you want to designate someone other than your spouse as a beneficiary, say in a 401k, you can't do that without getting your spouse to consent. So anytime we do a beneficiary designation form and we're trying to designate someone other than the spouse, be it a trust or another individual, we need to get the spouse's consent.
Okay, in the Smoot case, father divorces Diane but keeps $1 million in insurance on his life for his ex-wife's benefit. Now, he's supposed to change the beneficiary designation on his pension benefits, his life insurance, and his IRA, but he never does. So as a result, is it really true that the ex-wife gets all the property that still names her as a beneficiary?
Mike, it is true. I do want to point out that this is a very unique case based on the statute in the state of Georgia. It's a unique statute. What the statute provides is that if someone gets divorced and then passes away, the provisions in the will for that person, for the divorced spouse, are revoked. The spouse is treated as predeceasing the decedent. But the statute in Georgia doesn't go any further than that. So if you designate a spouse as a beneficiary of an insurance policy or in a retirement plan, in a pension, and you get divorced, that's not covered by the statute. And as a result, the spouse gets to keep that property, the divorced spouse.
You're saying all this happens because father never updated his beneficiary designation. Now, this is a potential horror story for a lot of formerly married couples, isn't it?
That's absolutely correct. I mean, we're always counseling our clients in the event of a significant life event, a marriage, a divorce, a birth, a death, or a significant change in wealth, that you want to revisit your planning and make sure that you're covered for the situation at hand as it's changed. Another type of change that's important to revisit your estate planning and your beneficiary designations, Mike, is a change in your residence. So you might move from Georgia to New York or New York to Georgia, and what you thought the rules were changed significantly, and you really do need to revisit your planning in that situation.
The company that father founded wanted to do the right thing. They filed an interpleader action to ask the court to determine who gets the property. Is there anything that our viewers, as corporate officers and trustees of pension plans, can do in this situation?
Well, there might be, Mike. It might be possible to amend the plan to provide, similar to what the state laws provide in many states. That is, in the event of a divorce, the divorced spouse is treated as having predeceased the plan owner or participant.
In a similar vein, what about next fall, when individuals receive 1099 and 1099-R forms from their qualified plans? Shouldn't somebody remind them of their beneficiary designations?
Absolutely, Mike. You know, accountants frequently see their clients a lot more than the clients see the estate planning attorneys. So if they get an indication that there's been a divorce or a change, they should be referring that client to the attorney. Mike, I think it's important to look at your beneficiary designations all the time and review them constantly. Attorneys and clients, accountants and clients need to look at that not only when there's a birth or a death or a divorce or a marriage, and also when they're changing their residence.
Cozen O'Connor's Jeffrey Kolodny, thank you, as always, for bringing us up to date.
Thank you, Mike.
We've been discussing the type of tax planning that takes place, or should take place, after a court decision. But it's not just following Supreme Court decisions. After all, it's not every day that a $100 million tax deduction is at stake in the courts. So when it does happen, it's worth mentioning. Earlier this spring, the U.S. Court of Appeals for the Fifth Circuit reversed an earlier holding by the tax court. As a result, Pilgrim's Pride, the largest chicken producer in the U.S., was able to take a $98.6 million ordinary abandonment loss related to stock it held in a second company. Although most companies may not be in a position to argue or to use tax losses of that magnitude, this case involves a very commonly used tax planning technique. When can a partner in a partnership abandon his partnership interest in the hopes of achieving an ordinary deduction rather than a capital loss? Fortunately, the facts in Pilgrim's Pride are simple enough. In 1999, the corporation purchased $98.6 million of preferred stock in Southern States Cooperative. Southern quickly found itself in arrears on the dividends it owed to Pilgrim's Pride. And in 2004, Southern offered to redeem the stock for the sum of $20 million. Now, this offer put Pilgrim's Pride in a bit of a tax conundrum. While $20 million in cash sure sounds nice, had Pilgrim's Pride gone through with the redemption, it would have been treated as having sold the stock. As a result, it would have had a capital loss of $78.6 million. And because Pilgrim's Pride had negligible capital gains in 2004, it would have enjoyed no immediate tax benefit from the $78.6 million capital loss, although it would have the $20 million in cash. Seeking a better opportunity, Pilgrim's Pride exploited a nuance in the law. Rather than accepting the offer of $20 million, Pilgrim's Pride chose to accept nothing for the stock. In other words, they formally abandoned their ownership of the stock. So why would a smart company turn down $20 million? Under the tax law in place in 2004, no sale or exchange actually took place because Pilgrim's Pride abandoned the stock in Southern. As a result, the resulting loss was not capital in nature, but rather ordinary. And evidently, a $100 million ordinary tax loss is worth far more to a profitable corporation like Pilgrim's Pride than $20 million in cash plus an unusable $80 million capital loss.
Joining us is Robert W. Wood, who practices law with the firm of Wood LLP in San Francisco and is the author of Legal Guide to Independent Contractor Status, now in its 5th edition. Thanks for being with us once again, Rob.
Nice to be here. Thanks, Becky.
Well, economic conditions have been improving over the past year. As a result, the good news is that we are seeing more and more M&A transactions. The bad news is that, inevitably, some of those acquisitions may not pan out. But even if a deal doesn't work out, the acquirers can at least look forward to a tax loss, can't they, Rob?
That's really making lemonade out of the lemons. But yes, something doesn't work out, and certainly what investors want and what companies want is to write it off. It's kind of the American way.
Mike just gave our viewers the facts of how Pilgrim's Pride bought the preferred stock of Southern States Cooperative. Explain to me, Rob, why was it better for Pilgrim's Pride to turn down the $20 million redemption in cash that Southern States was offering?
I think that is one of these topics that probably sort of regular non-tax professionals might look at and really scratch their head. Because turning down cash money and saying you'd rather basically tear up the stock, treat it as worthless, and not take the $20 million does sound awfully strange. And yet, it's a good example of this notion of viewing things as taxpayers in our country must do or should do on an after-tax basis. It was actually better for the company not to take the cash because the tax write-off for the abandonment loss was much bigger and much better. Again, counterintuitive, but the numbers proved it, and it was very clear that Pilgrim's Pride made what I guess sounds, oddly enough, like the correct choice here.
Okay, it's been long-standing practice that abandoning a partnership interest results in an ordinary loss. So what basis did the IRS challenge the treatment of the $98.6 million loss?
There were two primary bases, as I recall. And interestingly, one of them is actually the point that you just made, Becky, which is the $20 million. That this company turned down cash. And so I think there was some discussion in the opinion about why that was, this was entirely tax motivated and it shouldn't get this ordinary loss deduction. I think the other basis in the case that the IRS argued and that the tax court agreed with was a more technical argument based on Section 1234A of the tax code, which is a sort of an odd provision that deals with ordinary versus capital, and essentially says that you are supposed to get capital loss treatment, not ordinary loss treatment on certain kinds of contract terminations. It was expressly put into the law, as I understand it, to do that, probably not on these facts, and I think it was a bit strained, but the IRS argued, the tax court agreed that 1234A applied on these facts.
So the bad news was that the tax court agreed with the IRS. The stock was a capital loss, and any loss was capital. Why did the Fifth Circuit look at it differently?
Well, I think the Fifth Circuit, which was a big taxpayer victory, the Fifth Circuit looked at both of the points that we just discussed. That is, this sort of notion that there was something wrong with turning down the cash to come within what was a clear line of authority that would support ordinary loss treatment, and the Fifth Circuit said that's okay. I mean, that is, it's almost, I don't remember if the Fifth Circuit quoted learned hand, but the court might well have done so. The old famous quote about it's not, nothing illegal about, and about arranging your fares to pay as little tax as lawfully allowed. That is what taxpayers do, and really what taxpayers in the system are supposed to do. And so it wasn't bad that Pilgrim's Pride did that it engaged in this economic analysis, and it was better off to abandon. And I think the other thing the Fifth Circuit did was to pretty much shred the argument that 1234A applied. It really didn't, and part of that analysis was going back to the established authority that, including IRS rulings, that said that you could, as a partner in a partnership, abandon a security, abandon a partnership interest, and that was exactly what Pilgrim's Pride did. So the court said, this isn't a closed case, although it may have upset the IRS, it may have even upset the tax court. Pilgrim's Pride wins this one, and it was an ordinary loss.
Well, what about our viewers, Rob? If they're in the same position as Pilgrim's Pride, but they're not in the Fifth Circuit, do they now have reasonable authority to deduct their abandonment losses?
Yeah, I think so. I mean, I think this would have been an outlier case, or it was an outlier case until it was appealed. So I think most people, myself included, feel pretty comfortable that the abandonment authority is reasonably strong, which doesn't mean that you're always going to win. It doesn't mean that you don't want to be careful. And I think, at least from what I read, Pilgrim's Pride was pretty careful. So I think it's a big taxpayer victory, and it doesn't mean that there won't be other cases, but I would say I wouldn't worry too terribly much about being in another circuit.
Well, what about those viewers who don't have a $100 million deduction that's pending before the courts? What's their takeaway from this case, Rob?
I think it would be something that I hope you won't view, Becky, as a changing of the subject, but rather to go back to what Pilgrim's Pride did when it was looking at whether it should take the $20 million or not. And I want to relate this, if I can, to an area that we've talked about in the past. As you know, one of my favorite topics, and that would be taxation of damage awards. And so, and to plug my other book, The Taxation of Damage Awards, it would be that topic, which looks at not so much corporate transactions, which is what Pilgrim's Pride was doing when it was deciding should it take the $20 million or turn it down and handle the issue on its tax return. And we know it did the latter. But I think in the litigation area, which companies and individuals face all the time, that kind of mantra should also control. That is, think about after-tax effects. In litigation, if you're a plaintiff or a defendant, think about what it is, and hopefully think about this before you pay the money if you're the defendant, before you sign the settlement agreement if you're the defendant or the plaintiff. Just think about, as Pilgrim's Pride did, think about which is better, because I do sometimes, in fact fairly frequently, see plaintiffs or defendants that don't think about it until after the fact and it's tax return time. And it's not that you can't do anything at all then, but you certainly don't have the kind of flexibility that you do earlier. So I guess my message is, in litigation, in addition to in corporate transactions, think after tax when you can.
Expert commentator Robert W. Wood, thanks as always for bringing us up to date.
Thanks, Becky.